Welcome to our lecture on December 23 patent case studies in India. Actually, after 1995, when India became a member of the WTO TRIPS agreement, there had been a lot of legislative activity in the area of IPR. The process began in 1995, but it took about almost 10 years for all the legislations to fall in place. There had been extensive amendments to almost all forms of IPR. So, the public interest in institution of industrial property system in India is on the increase. When I got into profession way back in 1980, IPR litigations is like tourism in Antarctica. Everybody knows where it is, and everybody know they are exotic places, but nobody wants to go there. That is how the situation is. At least there is a good lot of tourism in Arctic. We'll not get into that. Tourism in Antarctica is non-existent, but we all know it is an exotic place and it holds a lot of promise. IPR system is like that. By and large, people have been indifferent to IPR system during the 20th century. After 21st century, after the advent of 21st century, suddenly India had catapulted itself as among one of the six large economies of the world. And it is a question of time before we become the third largest economy. And by and large, there has been a technological transformation within the country occurring. A lot of people are going out, they are going to different places, they participate in R&D, they are instrumental in creating new technologies, implementing high technologies that were created by others, and there is a lot of activity. Even if you look at the filing statistics of the IPR offices around the country, the overall interest of even Indian IPR aspirants is on the increase. And this has resulted in more IPR litigations around the country. With this introduction, let me talk to you three important cases. I'll be focusing three cases. One case is by the Delhi High Court given by Justice Pratibha Singh. Two judgments by Madras High Court given by Justice Senthil Kumar Ramamurthy. These people are relatively young judges, I'm sure that this adjective is not good when we talk about legal competence and precedent-setting cases. I just said it, fine. Now, what I'm trying to tell you is, among the older generation of judges, not many people really wanted to take IPR cases, that's a digression, but let me talk to you about three things here. Three judgments. Two judgments were given by Justice Senthil Kumar Ramamurthy, Mr. Justice Senthil Kumar Ramamurthy, and one by Justice Miss Pratibha Singh. I'll first consider the Delhi High Court judgment. I am picking up these things not so much to talk about patentable subject matter, patent infringement, patent management, etc., but about the exercise of powers by the examiners and the controllers in the patent office and attempts to judicial review, attempts to get these acts redressed in a judicial review. Now, we all know that under the Patent Act, not all orders passed by the controller of patents are appealable. When there is no appeal, there will always be a writ. But even when a non-appealable order, we file a review and if it is rejected or allowed one way or the other, and all orders which were subject matter of a review jurisdiction under the IPR legislations become appealable orders, we leave it like that. Now let us talk first about, what I am trying to tell you is that the number of appeals, okay, by the applicants are on the increase. And that is a very nice thing actually. People are getting interested in the system and they are challenging the orders passed by the controller. See, there are two things actually. Number one, substantive compliance, and number two, procedural compliance. When I say substantial compliance, under patent law, for me to qualify for patent, I should prove novelty, utility, non-obviousness or inventive step, and statutory subject matter. If I comply with these four requirements, I am entitled for a patent. But over and above these substantive requirements, there are a lot of procedural requirements, like you must comply with the doctrine of the unity of invention. And when the invention relates to the use of biological material, you will have to get a permission from the National Biodiversity Authority. You must make sure that claims are precisely and succinctly defined. This is very important. 3. There must be adequate disclosure in the patent specification for you to demand a specified area of monopoly in an industrial process. These are all procedural requirements. The substantive requirements are laid down under the Patent Act. The procedural requirements are found not only in the Patent Act, but in the patent rules and also the manual of Patent Office, which they have come up for their own internal guidance and ensuring standardization, etc. These two things. Now, I'll now begin with the Procter and Gamble case of Delhi High Court. Justice Pratibha Singh. The patent related to detergent compositions, and the objections which were made by the patent office is that there seems to be no objection on the ground of fulfillment of substantive criteria. Novelty was there, utility was there, non-obviousness was there, statutory subject matter was there. The patent office issues the first examination report. And if there is an objection for substantive non-compliance, it will have to come in the first examination report. And the applicant often makes amendments to the claim, and he cites the fate of the foreign patent applications relating to the same invention. If they have matured into patent elsewhere, there is no reason the Indian Patent Office should refuse it here. So all these things. Now, the Patent Office in this case, very interestingly, came up with objections like the claims are not clear, the claims are not precisely defined, the area of monopoly claimed had not been brought out. So, these kind of objections are raised actually. And on that ground, the patent was denied. Procter and Gamble, they have what I call a big portfolio of patents all over the world, and they are used to dealing with the idiosyncrasies of patent offices around the world, and they filed an appeal. And this case, in my opinion, is a sort of when an examiner is going to reject a patent application, or it's not the examiner who rejects, it is a controller who rejects actually, all right, on the ground that the claims are not clearly worded. Okay, the claims are not precise. The claims do not sufficiently define the invention. There is no disclosure in the patent specification to justify this claim. Now, the Patent Office Delhi says very, very clearly, look here, you must give reasons as to why the claim is not clear. What is lacking in terms of clarity? And why do you think that, in other words, patent offices around the world give a reasoned order for rejection of a patent application? If a patent office is going to allow a patent application based on the recommendation of the examiner, the patent office need not give a reasoned order. Just accept it for grant. That's all. Over. Issue the patent certificate. Because, he is simply following the recommendations given by the patent examiner. If the patent office is going to allow a patent application and order that it should proceed for registration, then they don't have to give a reasoned order. But when the patent office is going to reject a patent application, they are under an obligation to give a reasoned order. It is not enough for you to say that the claims are unclear, provided there is substantive complaints. It's only the procedural complaints that the High Court was concerned about. Then it also remands the matter to the controller of patent and says, give a hearing, and it further says that complete the hearing within 3 months. All these things are very nice in my opinion, and they augur well for the image of the patent office, that it is becoming increasingly patentee friendly. This is very important. India is one country where there is a strong anti-patent bias. Okay, fine. So therefore, it will be easier for the patent office to reject a patent application than allow it. This is one part of it. The second judgment is from the Madras High Court. This related to divisional application. Okay. And the patent was rejected on the ground that there is no adequate disclosure. And in fact, this adequate disclosure, you must know what is a divisional application. Many of you know it. Under the Patent Act, there is a concept called unity of invention. Unity of invention means that every patent application must relate to a single invention. Now, earlier, there were doubts and questions as to how many independent claims that a patent specification has. Main claim, first claim, is an independent claim. Now, over and above, for example, let us take the concept of unity of invention. Unity of invention simply says that an application must relate to a single invention. Now, what is a single invention? Suppose I come up with an apparatus where a chemical process is to be carried out. This apparatus is a new apparatus. Number 2, the apparatus is meant for ensuring the efficient performance of a process. Let us assume that the process is also new, essentially because the apparatus is new. Okay, so it is a new process, and apparatus is going to have its unique features, and the process will have to be new in order to give that. Then 3, okay, and it is used for the purpose of producing a novel product. Okay, composition of matter. The product is also new. 4th is use of apparatus or product or this thing. So when there are 4 independent claims in a patent application, it can still come within the ambit of the unity of invention. Because it's one invention, but that invention has 4 different inventive concepts, and each one of the concepts are closely connected with the other. So one use, a use patent is a problem, and in Indian Patent Office, usually they permit one use of the product or apparatus or process, and so that there are no more than 4 independent claims in a patent application. There are a lot of people, they say that only one independent claim. If there is more than one independent claim, there will be a violation of the concept of unity of invention. And what is important is that when the divisional application was filed, And the patent office rejected it on the ground that there is no adequate disclosure. Usually in all, when the patent orders are reversed, even that is what Justice Madam Pratibha Singh did in Procter and Gamble case. You remand the matter to the controller because please remember, finalization of a claim is a highly technical matter, will involve about 80 to 90% of technology and just 10% of law. So the judges in their wisdom, in my opinion very rightly, remand the matter to the patent office and say, hey, you decide the matter afresh and you are wrong. And that's what Justice Sendil Kumar Ramamurthy did in the earlier case, which I discussed in one of my last lectures actually. Now in this case, Justice Sendil Kumar Ramamurthy goes to the extent of saying, hey, look here, there is adequate disclosure, grant them patent. So what I'm trying to tell you is that, very often the examiners and deputy controller or assistant controller. Examiner gets promoted to assistant controller, deputy controller, controller general of patent. This is the hierarchy. So most people begin their tenure as an examiner. Now when they become assistant controller or deputy controller, they really don't know how to judicial proof their orders. They are not often good with the principles of natural justice and how to write an order. This is very important, and writing a patent specification is different from passing an order which will withstand the scrutiny of court. The court looks for other criteria. They also have their own procedural compliance. So it's a very nice thing that the Indian judiciary, particularly Delhi and the Madras High Courts, have been passing the right kind of orders that will enable India to shed the image of having an anti-patent bias. Okay, ladies and gentlemen, that's the end of the course, and I know that there is going to be a patent agent exam recruitment to the examiners. So I have put up courses, more than about 20 hours of, more than about 25-30 hours of video online. Check out my courses. Thank you. Links are provided in the thumbnail. Bye.